Okay, so a couple people messaged me and want me to break this down. Okay, this is very simple. This is really in all 50 states. This is a United States Constitution principle. Then, obviously, some people don't know that there's a hierarchy of law in the United States. They just kind of forget that, but there is. You've got the federal Constitution. You got the laws contained therein, some of which are shepherdized. If you don't know what that is, you have to look it up. And obviously they grant powers to the state. Well, the state can't impose anything that goes against the Constitution. But, you know, our legislature, they often do, and people don't fight it. Well, see, that's the problem, is because we're an ignorant citizenry. And we've been warned about this a million times. So, let me get on to the matter at hand. Okay, to hold a constitutionally elected office in really any 50 states, you have to have a three-party agreement. Okay, the principal would be the elected official. The surety is going to be the one who indemnifies against a breach of public office. So the obligor is going to be the people and the governor of whichever state. Okay, like I said, the principal is the one holding office, and the surety is the one that steps in the shoes of the principal to handle that breach. Now, why this is substantially different than a legislative matter when they try to bring in these insurance pools and they draft a blanket coverage insurance policy that covers, you know, all elected officials or whatever, is because that's only a two-party instrument. Article 2, subsection 5 clearly states, shall give bond. It doesn't say may give bond, shall. It's a directive, it's a mandatory, it's a prerequisite. It's there specifically designed by the founding fathers and the other people who set up this government. You have to give bond, oath and bond. That's duly certified. Oath and bond, not singular, it's plural. Now legislature has tried to come up with this crafty, very crafty reach around, because there may be some honest bar members, but ever since its inception, the bar members have really tried to stifle our rights. But they did a good job because we have so many distractions. So there's a lot of, I'm not going to call people stupid, but I mean, they're taking their kids to softball, they're, you know, watching Honey Boo Boo or whatever they're doing this decade. Okay, it makes no difference. There's design distractions to keep you away from looking into things like this. Okay, now this, like I said, this is across all 50 states, and it's your duty as a citizen to know, understand, and interpret these things. And if they're not holding up their end of the bargain, I mean, if you consent to these things by acquiescence and you don't speak up, well, guess what? Then, I mean, they're just going to keep on doing it. So, like I said, it matters if you're in Hawaii or Florida or Massachusetts. It doesn't matter. It's the same thing. This applies across all 50 states. Now, there may be people smarter than me on this. I've studied this at quite a length. There is significant case law in all 50 states where if people didn't meet this three-party tier, well, they did not meet all the requirements to hold office. And so, I mean, that's where you need to be attacking this stuff at. Things like this, you know, you can go in there and argue all this other frivolous bullcrap and you're going to get laughed at. But this right here, this is a gold mine, because almost all your municipalities, counties, and state are operating like this. Now in Florida, they have Florida Statute 7/16, which is a waiver of sovereign immunity, but you can't waive something you never had by implementing this. You can't waive immunity if you never, ever met the qualifications to hold office. So you can do with that information what you will, but these are facts, okay? These are facts. Now, the crazy thing is, you can go and you can do a public records request, and a lot of times they will obfuscate. They will throw these things to the side and try to gaslight you, okay? But the fact remains, they have to have this three-party agreement. It's a constitutional mandate. And like I said, the hierarchy is, you know, your Board of County Commissioners or your legislative acts do not in any way supersede the Constitution. The legislation is very crafty, and they will do whatever you allow them to do if you stay ignorant of the facts. I mean, they're literally committing treason. But these are the little things right here that are legit and that need to be handled and brought to way higher authority than, you know, your local. You know what I'm saying? And like, actually, you really need to do this stuff in federal court, because the fact is here, they all play in the same sandbox. Your county officials, let's just say they were a bar member and he started as a public defender, he rubs elbows with a certain judge in the district, then he's promoted to prosecutor, he plays prosecutor for 5 years, and before you know it, he's a circuit judge, and then within a decade or 5 years, he's a chief circuit judge, and so forth and so on. Then he just elevates to the District Court of Appeals, and then you have no remedy, because the whole sandbox is tainted. So if you go and play with the bullies, you don't play in the bully sandbox, if that makes sense. Peace.